Hi, I'm attorney Jason Carnell, and thank you for watching this video. Today I'd like to tell you a little bit about pretrial intervention, PTI, or diversion programs in the state of Georgia. Think of PTI or diversion as probation without a conviction. OCGA 15-18-80 is the statute that authorizes the Solicitor General or the District Attorney of your county or judicial circuit to create this program known as PTI or diversion. The statute specifically states that it shall be the purpose of such a program to provide an alternative to prosecuting offenders in the criminal justice system. Now, what this means is that these programs are set up as a way around prosecution. If you're eligible for PTI or diversion, you will be subjected to some probation-like conditions without actually being on probation. You see, probation usually follows a conviction or a plea of guilt. However, with pretrial intervention or diversion, these probationary conditions come before any plea of guilt or conviction. Furthermore, should you complete the program, you will actually never face having to plead guilty or to suffer a conviction. Following the completion of your probation-like conditions, your case is usually null prost, which is a fancy word for dismissed. Unfortunately, whether or not your county has such a program is entirely optional. Nearly all the metro Atlanta counties have PTI or diversion. Most rural, non-metro counties do not. This creates a pretty significant difference between the level of punishment you can expect to receive for, let's say, misdemeanor marijuana possession in metro Atlanta versus a rural Georgia county. Also, the statute reads that PTI or diversion may not be offered for what the statute calls an offense for which law provides a mandatory minimum sentence of incarceration or imprisonment that cannot be suspended, probated, or deferred. In other words, DUI. That's probably the most commonly charged offense for which PTI or diversion are never available. But of course, it's not the only one. Next, different solicitors and district attorneys have vastly different criteria for qualification for the program. For example, one particular solicitor's office offers PTI or diversion for misdemeanor marijuana possession, but not if there is evidence that you were smoking it. So, if the officer who makes the arrest lists the smell of burning marijuana in his police report, you're not eligible for diversion. This is obviously an absurd distinction, because what else were you going to do with the marijuana? If you sell it, that's a felony. So don't expect any semblance of consistency or logic in qualification for PTI or diversion from county to county. They're really just all different. Finally, as probation has become a haven for special interest moochers, the PTI diversion programs are not far behind. You see, certain special interests benefit from probationary convictions. The judge or the prosecution recommends that you complete Program A or you be subjected to Evaluation B. As such, the beneficiaries of that probation lobby those with the power to impose additional conditions. They do so for the purpose of increasing their profit. Well, the same is becoming true for PTI or diversion. For example, one prosecutor's office makes DUI school, mandatory for people charged with misdemeanor marijuana possession. Now, this imposition only makes sense when you ask yourself, cui bono? Or, as a benefit to whom? Who benefits from this? Now, I fully expect for this unfortunate trend to continue. If you or someone you know has been arrested or charged with a crime, you should consult with an experienced attorney regarding your possible eligibility for pretrial intervention or diversion. Please visit my website at www.carnellfirm.com. You can contact me with your questions at jason@carnellfirm.com. And of course, you can always pick up the phone and call 770-389-0000. 322-4990. Thank you for watching my video, and I look forward to hearing from you.